Good afternoon and welcome to the North Carolina Court of Appeals. Your panel this afternoon is to my right, Judge Valerie Zachary, to my left, Judge Toby Hampson. I am John Tyson. We have one case on the docket for argument this afternoon, Benjamin Eagles versus Discovery Insurance Company. Our courtroom clerk today is Mr. Eddie Saunders. Our court marshal is Marshal Tom Salou. I do know here that we have both parties are both appellants and appellees. Have y'all discussed on how you want to split up your time and whether or not you want to cover everything in your principal argument or if you want to argue them separately?
We did briefly, and I live for 30 minutes, and I'm fine as the second appellant. My 30 in one block, and it's strategy.
Okay.
I don't know these weeks talk about which arguments to address in each block. I guess my suggestion would be having a block and we'll talk about all of those.
Your time is your own, and we will not direct your argument, so you can direct that as you see fit, okay? All right. Are there any other preliminary matters to come before the court?
We would like to reserve 5 minutes for rebuttal, and also thank the court for setting this special session to accommodate my trial schedule.
Thank you. Okay. Thank you. Okay. Well, then we will hear from the appellant, which is for Mr. Eagles, right?
Yes, Your Honor. Good afternoon. May it please the court. I'm David Stradley of the Wake County Bar, here on behalf of Benjamin Eagles, receiver. We all depend on our automobile insurance carriers to defend us in the unfortunate event that we cause an accident, and any of us could. And this case is about whether an auto insurance carrier can, with impunity, breach that duty to defend. I'd like to begin today by addressing sort of let me sort of give you an overview of our argument. I want to start with this motion to dismiss issue in terms of whether the receiver has standing, and we'll talk about 4 subpoints under that. They hopefully are on your screen now. This is the wrong action in which to challenge the receiver's authority. There's no appellate jurisdiction to hear that challenge. Discovery is the wrong person to challenge the receiver's authority, and the challenge would fail on the merits if it were heard. Secondly, I want to talk about the trial court's error in ignoring this court's binding precedent on Unfair Trade Practice Act damages, notably Nash Hospitals versus State Farm. And finally, I want to talk about the trial court's correct finding of the breach of the duty to defend, which triggered the treble damages in this case. So beginning with the challenge to standing. Under binding precedent from both this court and the Supreme Court, a receiver is subject only to the jurisdiction of the court appointing that receiver. In this case, that was the Wilson County Superior Court in the underlying action. This is a case where there was an underlying lawsuit. There was a tortfeasor, Mr. Cherry. He got sued by Mr. Tomlin. Mr. Cherry was insured by Discovery. Discovery did not defend him. A $3 million default judgment was entered against Mr. Cherry. Mr. Cherry could not pay that judgment, and a receiver was appointed by the Wilson County Superior Court to take possession of Mr. Cherry's claims against Discovery Insurance, and the receiver brought those claims in this lawsuit, which is a Nash County lawsuit. So we're going to refer to those as the Wilson County action and the Nash County action. And again, under this court's binding precedent and that of the Supreme Court, the only court with jurisdiction to say what the receiver can or cannot do or has standing or anything of that nature is the appointing court. And Discovery actually recognized that in the trial court proceedings here. I've shown you the motion that they filed to discharge the receiver and terminate the receivership, and you'll see that that was filed in the Wilson County action. And you'll see that an order was entered on 9 August 2024 denying that motion in the Wilson County action. And you will also note that the record on appeal in this case is devoid of any notice of appeal from that order, and that action is not on appeal. And again, under Rule 3 of the Rules of Appellate Procedure and long line of precedent, a failure to give notice of appeal of an order is jurisdictional in this court. And so this court has no appellate jurisdiction over a challenge to the receiver's authority. That the court could have had that jurisdiction had the Wilson County action been appealed, but that hasn't happened. There's been no petition for writ of certiorari or anything to address the Wilson County action. So from a jurisdictional perspective, the challenge to the receiver's authority is a dead letter. Secondly, as I indicated, Discovery is the wrong person to challenge the receiver. Under this court's precedent in Harhouse versus Cheek, the debtor of a judgment debtor, which is what Discovery is here, the judgment debtor is Cherry. Discovery is Cherry's debtor. The judgment debtor of the debtor of the judgment debtor has no standing to challenge the receiver's authority in any way. Can't challenge the receivership. And again, that's in the Harhouse case, binding authority in this court. Further, even if the court heard that challenge, it would fail on the merits. Discovery relies on a case called Wrighton from the Supreme Court, which was decided, I think, 10 years after the Civil War. But 20 years later, the Lenore case was decided by our Supreme Court, which expressly states that the Wrighton line of cases is no longer the law. And so even if the court were to hear that challenge, which it should not, and lacks jurisdiction to do, that challenge should fail. So turning to the substantive part of our appeal, the key issue in the case is and I'm finished with the moniker for now. The key issue in the case, from our perspective, is whether the trial court erred in holding that there were no damages after Discovery settled with Tomlin, the original plaintiff, for a 50% discount 3 years after the judgment was entered. And the trial court held that obliterated the plaintiff's the receiver's damages and Cherry's damages because that judgment got satisfied. That's what the trial court held. And that is wrong under a long line of cases: Garlock versus Henson, Vasquez versus Allstate, Seafair versus Traynor, Richardson versus Bank of America. This long line of cases from this court holding that unfair trade practices damages are trebled and then credited. And there were a number of different fact patterns in those cases that I just rattled off to you, but in every single one of them, there had been a payment or a promise to pay or something of call them the contract damages or the underlying damages, and the question was whether do you credit that money first and then treble what's left over, or do you treble the damages and then credit the money?
But you would have to concede that none of those cases are directly on point for this particular fact scenario.
None of those cases are, but the case they neglected to distinguish at all, which is Nash Hospitals versus State Farm, is on all fours.
But Judge Wilson distinguished Nash in his order.
And Judge Wilson was wrong.
Well, isn't Nash distinguishable in that in Nash they refused to accept the check?
Whether they accepted it or not, it was tendered and paid, and tender of a check is in fact, is payment. I mean, under the law of negotiable instruments, the tender of a check is payment. accepted or otherwise. And for example, in Garlock, there was this promise to pay. And by the way, the settlement agreement, which is in the record in this case, there is an executory contract. There were supposed to be payments made under the settlement agreement. And in fact, there's nothing in the record showing that payment has actually been made on the settlement agreement that Discovery reached with Timely. But setting that aside, the fact of the matter is what happened in Nash was State Farm settled a personal injury case. There was a lien under 44-49 and 50. And instead of resolving that and paying money to the hospital, they made the check jointly payable to the claimant, patient, and to Nash Hospitals. And Nash Hospitals did not accept that, never got that check because it was never negotiated to them, and sued. And then State Farm then turned around and paid Nash Hospitals more money than it was entitled to under its lien. I think almost twice what it turned out to be entitled to under its lien. And State Farm came into court and made the exact same argument that Discovery makes here, which is by sending that money, we erased the damages. And that simply, the court said, no, that's not the way it works. This court said that. You treble the damages first, and then you take the credit, which is exactly what Judge Wilson should have done here, is treble the damages and then take the credit. That is entirely consistent with the public policy behind the Unfair Deceptive Trade Practices Act. And by the way, the receiver, the plaintiff in this case, Judge Zachary, has not accepted any money. No money was paid to the plaintiff in this case, unlike the plaintiff in Nash, because this was a complete end run around the receivership. So this money that they're seeking to say wipes out the damages wasn't even paid to the plaintiff who controls the case and the claim in the case. So the fact of, and if you look at Discovery's briefs, actually took me a little bit by surprise. I looked at their table of authorities for the Nash case, and it was listed one time when they listed all the cases that we cited, and there was no effort to distinguish it.
So when the receiver, hypothetically, the receiver collects $3 million
Yes, sir.
from Discovery, what is the obligation of the receiver then with respect to that money vis-a-vis assuming the judgment had not been satisfied at that point? What would the receiver have to do with that money?
Had the judgment not been satisfied, the receiver would take that money. Well, first of all, if there were a $3 million judgment, the finding of unfair trade practices in this case has not been appealed. In other words, Judge Wilson's ruling that this constituted an unfair trade practice has not been appealed, so trebling is mandatory. So it would be a $9 million judgment. And so...
Well, I'm sort of taking that part. Maybe I'm focusing more on just, the obligation of the receiver to the extent it's to help satisfy the judgment.
Sure. Then, yes, the receiver would, if $3 million were paid, the receiver, per the terms of the order, would pay his expenses, pay his costs, his expert witnesses, his counsel, and then apply the balance to the judgment in the case. That's how it would work. And if there were treble damages, it would work the same way.
How long did it take from when the complaint was filed until the money was paid by Discovery?
Over 3 years, Your Honor. If you're talking about the receiver's complaint, it was over 3 years that Mr. Cherry had a $3 million judgment against him. And I would just, I would suggest that none of us sitting here today or standing here today would believe that, or would feel, if we had a $3 million judgment against us, none of us would feel that that was illusory harm, that harm didn't exist, that if somebody came back and paid that judgment after the fact, that we had suffered no harm. Which is exactly what... Judge Wilson did.
Well, Judge Wilson also sort of explored those concepts, right? And said, well, even if, like the judgment's been paid and satisfied, so I'm not going to award damages for that piece. But there's also no evidence of any sort of consequential damages or other harm that arose. Do you agree with Judge Wilson's?
That is true, Your Honor, because and there was no need to introduce that because the law, as we saw it and still see it, is quite clear that when an insurance company breaches the duty to defend, they owe the amount of the judgment. That's the Ames versus Continental Casualty case from the Supreme Court, and so that law is clear. Anything else would have sort of been gilding the lily. He did suffer an execution. That is of record in the case because there had to be an execution for the receiver returned unsatisfied for the receiver to be appointed.
And that's one of the things like Nash County the Nash County case kind of talks about, which is it's the delay in receiving payment that is the harm. Is there any difference in the measure of damages just from the delay itself versus the amount?
Except that wasn't the measure of damages in the Nash County case, right? The measure of damages was the lien amount that they were. It was not. If it were merely the delay damages, then it would be some amount of interest on the lien amount. That would be compensation for the delay. Instead, that's not what the court said. That's not what this court said. It said the damages are the amount of the lien, which is then trouble, and then credited back with whatever amount has been paid. And we certainly agree that to the extent there has been payment made on the settlement agreement with Tomlin, which it may not have been fully satisfied at this point, we certainly agree that that is a credit to be applied after the trebling in the case. Discovery's sort of big issue in the case is the notion that the trial court erred in finding a breach of the duty to defend. But Discovery has failed to appeal a crucial finding in that respect, which is that there was an anticipatory breach of the policy by Discovery prior to the underlying lawsuit ever having been filed. And if we can go back to the monitor, I can show you that on page 253 of the record, at the bottom of the page, Judge Wilson concluded that Discovery's statement to Tomlin and his attorney that, quote, there will not be any coverage for Tomlin because our policyholder's vehicle was stolen, which was communicated to Cherry, along with Discovery's failure to, top of page 254 of the record, provide a defense to Cherry after it received the complaint, constituted a breach and anticipatory breach by Discovery, excusing further performance by Cherry under the terms of its policy. You will find no challenge to that in Discovery's opening appellant brief in the case. And under this court's precedent, which is cited in our memorandum of additional authority, that argument has been waived. Therefore, Judge Wilson's finding in that regard is binding. There was an anticipatory breach which excused Cherry any performance by Cherry. So Cherry had no duties following the anticipatory breach. But even setting that aside, there's undisputed evidence of a failure to investigate in the case. Discovery's executive vice president testified in her deposition that an insurance company must follow its own investigation procedures before denying a claim. And she says, I agree we must properly investigate a claim using our guidelines as a framework to determine if coverage is afforded. And Discovery, in fact, had a claims manual, and it had a section on investigations, and it said that every file requires a thorough investigation and should be carried out until there are no unanswered questions. And so in the 30B6 deposition, the adjuster was quizzed on What unanswered questions were there at the time this claim was denied by Discovery? And in fact, there were some 13 conceded by Discovery. This was an exhibit made on the fly in the deposition. Some 13 unanswered questions that Discovery's investigation had not addressed at the time the claim was denied. They didn't know basic things like Cherry's phone number or his address, whether he was willing to talk to Discovery, whether he had driven the vehicle before, how often he had driven the vehicle before, what his understanding was of whether he was allowed to drive the vehicle, whether Tomlin had ever ridden with Cherry in the vehicle before, what the ultimate outcome of law enforcement investigation of the theft charge was, whether the theft charges were dropped, if they were dropped, when they were dropped, and what statement an investigating officer would have given if asked.
Did girlfriend recant her accusation?
The girlfriend has, there is no record testimony of what happened to the girlfriend or the girlfriend's testimony following her limited communications with Discovery early on in the case, in the claim. That's all there is. She was not deposed, nothing of that sort. Charges were dropped, but there's nothing else in the record. And so there was a clear breach of Discovery's admitted duty to investigate claim, and therefore an anticipatory breach. And then Discovery knew that Cherry was insured under the policy. Again, this is 30B6 testimony. Knew Cherry was insured under the policy, knew he had been sued, his name was on the documents as a defendant. And so, and yet, as Judge Wilson correctly found, no defense was afforded to Mr. Cherry. Further, the undisputed evidence shows that, and we're finished with the monitor, the undisputed evidence shows that Discovery didn't want Cherry to know about them. As there was a colloquy between the girlfriend, Ms. Sauls, and the Discovery adjuster, where Ms. Sauls says, my ex is trying to find out who my insurance is, and the adjuster says, well, and Ms. Sauls says, I'm not going to tell him, and the adjuster says, well, we wouldn't pay anyway. And so Discovery had access to Mr. Cherry, could have easily had access to Mr. Cherry, and simply chose to ignore Mr. Cherry, ignore this claim, do nothing to investigate the claim. And again, the undisputed evidence of record in this case is that the vehicle was not stolen. And Discovery has brought forward no evidence that the vehicle was in fact stolen, could have deposed Ms. Sauls, chose not to do that. So that is the record before the court today. And therefore, Judge Wilson found, which again I believe is unchallenged, is that the uncontested evidence shows that Mr. Cherry acted in good faith, and certainly under all the circumstances acted in good faith. You know, this does involve a little bit of an odd scenario in that Mr. Cherry was driving somebody else's vehicle. It wasn't his car. He didn't know who the insurance company was. It's not like he could have reached in his wallet and pulled out the insurance card like we can probably do for our own cars and know what number to call. He was asking Ms. Sauls for the information, and that was not forthcoming. And so Judge Wilson correctly found, even though it's surplusage, given the anticipatory breach finding, that Mr. Cherry acted in good faith, and therefore under C.G. Tate versus Great American, there was a duty to defend. And then just briefly, I will touch on the attorney's fees issue, and all I'll say about the attorney's fees issue is that if the UDTP damages is overturned and is remanded for entry in accordance with the Nash line of cases, under Kuykendall versus, let's see, United Laboratories versus Kuykendall, the outcome achieved is relevant to the attorney's fee award. And therefore, if the outcome changes significantly, the court should reconsider its attorney's fee award in light of the changed outcome of the case. So we would suggest that if the UDTP damages is overturned, as we contend it certainly should be, that the case should be remanded for reconsideration of the attorney's fee award in light of the change in the result.
Do attorneys in Nash County routinely handle cases of this type, or is this a specialized area of law?
This is an extremely specialized area of law. I don't know of anybody in North Carolina who does more of it than I do. And I practice in Raleigh and I practice statewide. This is not something that is typically done. The Harhouse case, which authorized this, which authorized the receivership procedure, was my case that I tried in the underlying and appealed up through this court, and then my co-counsel was counsel on the second appeal, and so this is quite specialized work. This insurance bad faith work.
Were you in Intrepid also? Intrepid agency or in
I was not in the Intrepid agency case. I had a case that had a similar issues to the Intrepid case.
But it was
came up
Nash
shortly
again,
thereafter.
I think. Yeah.
And so those are the points that I'd wish to make and reserve 5 minutes. Thank you, Your Honor.
You have about 5.5 minutes reserved. Hear from the appellee and the appellant thereafter.
That's right, Your Honor. Thank you, Your Honors. Again, my name is Josh Bennett. I'm from the Forsyth County Bar. I'm here with my partner, Mitch Blankenship, and we're honored to be here representing Discovery Insurance in this appeal and cross-appeal. Just as an opening point, I find that lay people often think that what lawyers argue about is what the answers are. And I think what we actually argue about is what the questions are. Because once you frame the question correctly, the answer usually presents itself. And here, talking about the receivership issue, the question that we are asking the court to answer is not, did Judge Wilson err in failing to discharge the receiver, because I think we'd have a problem there. What we are asking the court to answer is, does the receiver still have, and did it have after that judgment was satisfied, standing to pursue any more claims of any type, including this one? And the answer is no. And because there is no standing, there is no subject matter jurisdiction, either at the trial court level or at this level. And subject matter jurisdiction cannot be waived, it cannot be consented to, because it is for the court really to determine whether it's there. And so what I do or don't do has no effect on your ability to determine subject matter jurisdiction.
But aren't these issues like all sort of interconnected? Because your argument, it sort of goes, you can call it standing, you can call it damages, but it sort of boils down to the same thing, which is, did satisfaction of the judgment extinguish all liability and therefore render the receiver?
I think the satisfaction of the judgment answers both of those questions. I don't know that they are, it may be a distinction without a difference, but I think they are separate questions. Because one is just about, can you and can Judge Wilson hear anything that the receiver says? Does you have a right to speak on any issue? And we think the answer is no.
Why doesn't that then undermine the initial appointment in the other action of the receiver? Why is that not a collateral attack on the receiver?
Because subject matter is evaluated constantly, and subject matter can be gained and lost. And here...
But does your client have the right to raise that issue?
Oh, absolutely, because again, subject matter jurisdiction can never be waived, because it is really with you all to sit. So there's no action I can take one way or the other that's ever going to stop the court's ability to evaluate its own subject matter jurisdiction.
So are you saying anybody can raise it at any time?
Absolutely. The case law says you can raise it post-verdict.
In other people's cases?
And
If I
other
wanna-
people's-
if I-
Oh, I see what you're saying.
Yeah, that's,
I see what you're saying. So no, but there's a distinction, right? And because what the,
I think we all agree it can be raised at any time. The question goes to
do you have to raise it in that case?
who can raise it.
Right,
And in which case would it be raised?
right. And so, I follow that, but I have an answer to it. And the answer is, that we are not asking for this court to rule that the receiver has been discharged, right? All we are asking this court to rule, on this point anyway, is that the judgment having been satisfied, and the receiver only having a purpose to satisfy that judgment, he has no further purpose. He does not own, and critically, he does not own the proceeds to that claim anymore.
But doesn't the order appointing the receiver go further than simply satisfaction of the judgment? Doesn't it go further and say, and also to pursue claims that Cherry may be entitled to?
Judge Wilson made that point, but the answer is no, it doesn't.
Well, what about
Well, it doesn't-
expenses? Excuse me, I'm
Please,
sorry.
Go ahead.
No, go ahead.
Please.
So,
Because he had expenses for the attorney that he hired in Lenore to represent. So what about the expenses that he incurred? Because those weren't paid. So if you, it sounds like you're suggesting that the receivership should be extinguished
yes.
without any of that being satisfied.
Well, again, this is one of the plaintiff's arguments on the attorney's fees issue, right? Is not just that this is extremely specialized area of law, which it probably is also that there was a lot of risk attached here. And they got the bad side of that risk, right? They had a theory, and when the case started, they had damages evidence to support that theory. But by the time they showed up to the summary judgment hearing, that damages evidence didn't exist anymore. And so they got the bad side of the risk on this one. That is not for the court to fix. Just because there is a receiver appointed does not mean that, I mean, what Harhouse, and I know I'm speaking to the person that wrote it, but what Harhouse just said was, in these cases, you can have receivers appointed. It did not also say, oh, and by the way, they are guaranteed payment in every case, right? Here they are not. And once that judgment was satisfied, and again, this is the big...
But again, the only reason under this argument that they're on the, what, as you call it, the bad side of the risk,
Yes, sir.
is because in the middle of that litigation on the eve of summary judgment, your client ran and satisfied the judgment for, whatever it was, 50 cents on the dollar.
I mean, litigation is unpredictable and sometimes dangerous. And so, I mean, there are a million litigation events that can occur. I mean, we've all been there when something showed up in court one day and boy, that was not really good for me. It happens. And so what they're basically, in function, what they're trying to argue here is, well, we took on this job as a receiver, so we got to get paid. Well, I can tell you there's bankruptcy trustees all over the state that wish that were the rule, that just because they took on a case that they got paid, but that's not what happens. And but it's not just because that's not what happens. There's a reason, and Harhouse answers that question. If I dare to tell the person that wrote it, and I realize I'm always on dangerous ground when I'm telling a judge what they were thinking at a certain time, but the way I read Harhouse is Your Honor spent a good amount of time in that case talking about how allowing these types of receiverships was not an assignment, right? There's about a page, at least in my version, of talking about that. Candidly, I don't know that text was strictly necessary to get to the conclusion that you got to. However, it was very helpful in understanding the differences between a receivership and an assignment. And what we have right now is an assignment. It's called a receivership, but it's an assignment because, and you heard Mr. Stradley say it, that the plaintiff is the one who controls the claim in this case. Well, Harhouse makes a distinction between receiverships and assignments and says that assignments occur when there is a control of the claim. He just said that's what he has, and he's right. As he sits here right now, he is allowed to keep prosecuting this claim for no purpose that the court assigned the receiver. I mean, there's no judgment to satisfy. There is no judgment creditor to be satisfied. Mr. Cherry and Mr. Tomlin have been made whole.
How do you respond to the appellant's argument that that was an issue that was raised in the Wilson County case, and you lost that, and that has not been appealed?
So the way I respond to it is I can raise it in both places. Again, when we're talking about
once the court ruled, I mean, you can't hop between Nash and Wilson County trying to find a better, because every Superior Court judge is bound by, one can't overrule the other.
I'm with you on that. I don't think that's the issue. We absolutely argued to Judge Wilson that he did not have subject matter jurisdiction in this case.
And he denied, he sided with Mr. Eagles on that, correct?
In his opinion, in this case that we have appealed. And so I mean,
but the
again,
order from Wilson County, was that appealed?
No. But the order in this case that we are hearing, where Judge Wilson spends about a page saying that he has subject matter jurisdiction, and the reason he has subject matter jurisdiction is that our interpretation of Wrighton is incorrect, is in the order in this case that we have appealed. And so
are you saying the Wilson County order denying your challenge to the receiver is immaterial?
it is because again, just to go back with what I started with, I was asking a different question.
Okay.
I was asking the question there, Judge Wilson, will you discharge the receiver? And he said no. The question I then asked him, and which I also asked in this court, and again, I don't even have to appeal it, right? Because you all control your own jurisdiction. What Judge Wilson does not control what your subject matter jurisdiction is. And so, but we did ask to argue to Judge Wilson, and he refuted our position that he did not have subject matter jurisdiction at that time, and that has been appealed. So we have completely covered our bases on that point.
Well, okay, so they, of course, had to pay to file the complaint.
Yes, ma'am.
Okay, so is it your contention that the costs associated with the action are just lost because y'all did an end run around the receiver?
I think the short answer is yes. The long answer is I don't think that's a question you have to answer, right?
Well, I mean, because you're saying he should have been discharged, that there was nothing left for him to do.
Well, no. To be clear, in this appeal, I'm not challenging his not being discharged. I am simply, our argument is only that the receiver was appointed to and given the ability to pursue this claim against discovery insurance. His purpose has been taken away by the satisfaction of that judgment. And so he does not have the right under that order to continue. And that is a standing question. It is a subject matter jurisdiction question.
Going back to what Judge Zachary asked you, though, up until the time, number one, he was never removed. You agree with that?
Yes, sir.
Okay. Was he authorized under his appointment to hire attorneys? Was he authorized to incur cost?
Yes.
Are you saying that your settlement included those?
Again.
It's a yes or no question.
The answer is no, because our
Okay, if he had the authority, he had not been discharged, and the settlement, the payment did not include those items, why is Judge Wilson correct then in awarding the items that he contracted for during the period of authority prior to settlement?
Because Judge Wilson lacked the subject matter jurisdiction to do.
Well, you've already admitted that the receiver had the authority of the order to do those things, and the receiver was still in place on this case that you have before us today.
the receiver had not been discharged. But again, and the subject matter jurisdiction can change. And it changed when we satisfied that judgment. And once you lack subject matter jurisdiction, you lack it. It's over. And so there,
But what occurred before jurisdiction was lost would still be recoverable. Or not?
I think from a practical perspective, no, and here's why. Is that the receiver, once, at least in this action, the receiver, I think there is a world, again, and I don't think these are really questions, and again, obviously the court's got the right to answer what questions it wants to, but in this case, I'm not asking this court for a ruling about every single thing that happens with the receivership when it gets back to the trial court. All I'm saying is, because this court lacks subject matter jurisdiction, it can't consider the receiver's appeal. That's it.
Isn't the receiver appointed to serve until the court decides otherwise? That until the court decides,
Yes.
That the receiver's services are no longer needed? Or
Yes.
desired?
He has not been discharged, but that does not mean, I mean, again, following that logic till the end point, that would mean that the Judge Wilson's, I mean, just to maybe key off of what the point you were making earlier, that would mean that Judge Wilson's order denying discharge in a separate case controls this court's subject matter jurisdiction, a higher court's subject matter jurisdiction in another case. That's not how it works. And so and that's why the discharge and the SMJ are separate issues. This is just, does the receiver still have control of this claim?
Who should have control?
Jerry. And
even though a receiver's been appointed by the court, basically to recover his debts.
he has no debts.
Do you know that? You don't know that he has, I mean, perhaps.
There's no evidence in the record that receiver is there for any purpose, and that's a great point, because the Lenore case that they cite to is overriding, which it does not do, was a case where the court had identified other debts, and so the one debt gets satisfied, they try to remove the receiver, and well, no, we have these others to satisfy too. I mean, I have no idea whether Cherry has other debts or not, but there's nothing in the record that says he does. And so the only debt, I mean, it's the same issue with the damages that we were talking about is, I mean, theoretically, he could have other damages, but those weren't presented to the court. And we got to summary judgment, and nothing was presented there.
Which kind of goes to another point here, right?
Yes, sir.
The action here is not specifically to say, discovery, you must pay the amount necessary to satisfy the judgment. The claim here is an unfair and deceptive trade practices claim, which the claim there is that, discovery, you have acted in a manner affecting commerce against North Carolina public policy, and by statute, North Carolina is going to protect consumers and say, you're entitled to damages which are then trebled. So it's really a different claim that's being pursued under the receivership than just please satisfy the judgment, right? There's a whole public policy underpinning to the
receivership. I completely agree. The receiver's claim is not to satisfy the judgment. The receiver's claim is damages that Cherry accrued as a result of entry of the judgment, and that was under the receiver's theory and Judge Wilson's order.
So then why doesn't the Nash County case apply? I know I'm kind of switching
the Nash Hospital.
Yes, I know I'm shifting gears a little bit.
No.
Moving along here.
Nash Hospitals is not about that issue, and the facts are different. So in that case, and I'd direct you to this is at 739 in that case, and it talks about proximate injury, and the Allstate there was arguing, well, hey, we eventually paid them something, Now, again, I think the damages there was, well, you didn't pay the right amount, right? And so that's when there's a large discussion in that case on how you calculate the damages because they hadn't paid the right amount of damages. And so the Nash Hospital wasn't made whole there. But the point is that the defendant's failure to retain the funds delayed Nash Hospital's recovery of those funds to which it was legally entitled. So the damage, that delay constitutes injury, is what Nash Hospital says. And so all Nash, again, you've got to make sure that we are not conflating the concept of injury and the concept of damages and the amount thereof, right? And so what Nash Hospital says is that delay is an injury under the Unfair Deceptive Trade Practice statute. Well, fine, but the issue is that Hakeem Cherry was never owed any money, right? Like in the underlying case, he was the defendant. That is, Samuel Tomlin could have made a claim like Nash Hospital could because he was the one that didn't get paid. Well, we settled with Samuel Tomlin and paid him, and he released all his claims against Discovery.
But what Cherry was owed under the where we are right now, understanding you might dispute that, but what Cherry was owed was a duty to defend and cover the claim.
And and apparently suffered an unfair trade practice.
That is what Judge Wilson found, yes.
Yes.
And so the question there is when you get to the summary judgment stage, and again, I'm citing these old cases because I sound like I'm talking down to people when I say it, but I'm not meaning it that way. This is just elemental stuff, right? This is about when in a case do you have to present damages evidence. And when you file a complaint, you don't have to have any evidence at all. I mean, you need to file Rule 11, but you can. The day you have to present evidence is the summary judgment hearing. And when this plaintiff got to the summary judgment hearing, there were no damages. I think there were damages when the complaint was filed. There weren't at the summary judgment hearing.
And I think when in support of this argument, you cite Guessford,
Yes, ma'am.
which is a federal case.
Yes.
But is Guessford really helpful to your case when they settled before the suit was filed, or they paid before the suit was filed? And in this case, it was after.
I think it's dead on, and the reason is, and again, that's.
I guess her question is, does that make a difference that the settlement was before the filing of the complaint?
No, it does not make a difference. And the reason it does not make a difference is the filing of the complaint has no, there's no findings by any court about what evidence there is when a complaint is filed. And that's exactly that. I think it's an 1860-something case, Supreme Court case from this state that says evidence can change up until the time of the verdict. And evidence of damages can change.
Is this the Leitner case that was referred to earlier that was later clarified? Do you agree with the argument that that citation to the earlier case has been at least questioned?
I don't think that's the case I'm referring to. No, again, the principle that I'm poking at is really, I think there's part of the defense bar that would really not hate the rule that the plaintiff is asking for, right? Because what the plaintiff wants to do is just pick a point in time, whenever a plaintiff decides to file a complaint, and damages are frozen at that moment, and nothing can ever change. Well, that would go both ways, right? I mean, there'd be plenty of personal injury defendants that would say, great, that means future damages are off the table, and if you get worse after a car accident, you can't put that in evidence.
But I don't think that's the argument that's being made. The argument is really more as to when whatever credit against those damages should be applied, whether it should be sort of like treated as there are no more damages. And of course, we're talking about unfair and deceptive trade practices damages. We're not talking about just a breach of contract damages, right? So it's where do you get the credit? You get the credit on the front end or the back?
We don't get a credit because there is no credit. I know. Just stay with me.
Okay.
So
I'm trying.
So the sole evidence of damages in this case was the existence of that $3 million judgment. right? And that did exist at one point in time.
Right.
By the time they got to the summary judgment hearing, when you have to present evidence, that judgment did not exist by some mechanism. If Samuel Tomlin had just found it in his heart to go down to the courthouse and mark that thing satisfied, same result. However it got satisfied is irrelevant to the analysis. I mean, we did settle with him to get it done. That's true, but it's irrelevant.
So you're arguing that the satisfaction of the judgment, regardless of the other claims or other factors, would always bar any other claims or damages after that?
No, it would not. And Judge Wilson went through that and said, well, if there's evidence that he couldn't get a job, get a loan, anything else, well, yeah, then that would have been things I would have considered. There just wasn't that evidence. They are trying to create a completely new rule in North Carolina because they didn't develop evidence that they could have developed. And so there's no need to do that because there is a path in cases like this and I should also say, just as a policy matter, I mean, this is one of the few times with a Nadio case, I pretty well like it. I don't usually defend in cases, but in this case, we followed Nadio. Nadio says if you don't defend and a judgment or settlement gets entered, you got to go pay it. So that's what we did. And so we are right in line with what the case law asks us to do.
Let me ask you this, as it goes to Judge Wilson's award of attorney's fees and cost
Yes, sir.
and receivership fees. Do you agree, what do you contend is our standard of review of Judge Wilson's order or his conclusion?
Whether or not it's, well, so there's two pieces. But on the part that they are appealing, the standard is whether or not it's unsupported by reason. It's abuse of discretion standard.
All right, so the trial court has discretion to award or not award, and also the amount of the award, correct?
Once the door has been opened by the statute, yes. Now, so our arguments there are about whether 7516.1 actually opens the door for that discretion to be used. Once it's, under their theory, the door was open, and so he's just under an abuse of discretion standard. He meets that. I don't have any arguments against the amount because it's abuse of discretion. I have arguments about whether it should have been awarded in the first place. I've got 4 minutes, so I want to hit those briefly.
So that's what I'm trying to say. So you're claiming it never should have reached, the issue was not properly before Judge Wilson?
The ability to award the fees was not properly before him because the standard is, was there an unwarranted refusal to settle and was it done willfully?
Well, if he had no subject matter jurisdiction, he couldn't award attorney
course.
fees, right?
Well, I mean, my first argument is we need to run this thing back to the date the settlement was paid, kick the receiver out, and then see what happens.
But you lost that. You lost that argument.
Yes.
You lost that argument before in Wilson County.
Yeah. Well, I lost both arguments. I lost the argument in Wilson County. I lost the argument in Nash County. And so I just want to underline that part. But yes, the discharge argument was lost, and the SMJ argument was lost in this case.
Okay, well, Judge Wilson's order that's before us is presumed to be correct, and you have the burden to show error and prejudice to overturn it. Do you agree with that?
Yeah, of course.
Okay, so tell me again in the time that you have, and we will try to be generous, since we've asked a lot of questions. What is error and prejudicial about Judge Wilson's order that is before us today?
So on our appeal, the issue is, the main issue is that Judge Wilson found that we had notice of this claim, that there is not adequate evidence in the record to show that. The reason for that is that the Davenport case requires us to have received a summons against Cherry, which we have never received, is not part of the record. So there was no notice that ends the inquiry. The good faith, things like that don't matter. Now, on the good faith part, Judge Wilson found as a matter of law that that we had not shown bad faith by Cherry. That is not the standard. It is for Cherry to show, and in this case the receiver to show, that Cherry acted in good faith. The facts are that he knew he was about to be sued, that he knew his potential liability, and that he received the complaint and never called Discovery Insurance once.
But the evidence is also that Discovery had already said, we're not providing coverage.
So on that point, and I do want to spend a minute I got left on that, is I think that is a misstatement of Discovery's actions. Because, and again, this goes to like the concepts under coverage, where you do an indemnity analysis and you do a defense analysis. So what the record absolutely shows is that Tomlin, through his attorney, made a claim against Melanie Sauls on behalf of Samuel Tomlin. Definitely shows that. And that claim was denied, against Melanie Sauls, was denied because they thought the car had been stolen. That is a liability defense for Melanie Sauls. And that is a correct liability defense for Melanie Sauls. And so when they were asking for money from Melanie Sauls, Discovery denied that. Now, the plaintiffs in the court then has said, well, since you came to the conclusion that the car had been stolen, by implication, we can say, if you had been asked the question, which they never were by anyone, about whether there was coverage for Akeem Cherry, you would have then come to the conclusion that he had no coverage as well. That is, I mean, they're finding liability on that point, on the anticipatory repudiation point, regarding a decision that we were never asked and a decision that we did not make. The plaintiff, even in their brief, tries to make hay out of the fact that a witness testified that there was no coverage analysis and determination as to Cherry. They say that was a mess up on our point. Maybe so, but you can't say that we anticipatorily repudiated something when the only evidence is we didn't make a decision at all. And so but none of that, but that part doesn't even matter, because if there wasn't notice in the first place, then just the train doesn't, to keep using the analogy, the train just doesn't move and nothing gets started. And Davenport says there was no notice, and so we have no duty to do anything. And so I'm going to end on this. I use a bit of time in the brief to talk about the attorney's fees by Mr. Cherry's attorney that were awarded against us from his work in a different lawsuit, right? And obviously, our complaints about that are in the brief. I think my main argument here is that we are at the assignment stage. We are not at the receivership stage anymore. If the receiver can hire attorneys for Mr. Cherry to go argue that a $3 million judgment against him should be kept in place, which is what that attorney did, then, and continues to take, then we are at the point of claim assignment. We are not at receiverships. And so that is the core problem that we have right now is it's called a receivership, but we are in claim assignment territory. And so that's why their appeals got to be dismissed.
What would you have the court to do?
I'd dismiss the appeals and remand to the trial court for further findings.
Dismiss all appeals?
I mean, I think the problem is that, I mean, again, I realize that's not the greatest outcome for my own client because they'd like to see some end resolution here. But if I'm saying what I think the law says, it's that it's that everything that was done after that judgment was satisfied lacks subject matter jurisdiction. So I don't know what else you do. But I don't think in that, I'll finish, is that the concerns about is he paid, is he not paid, things like that, we don't have to go that far. We can just go to no SMJ, go back and figure it out. I'll leave it at that. Thank you, Your Honor.
Thank you. Rebuttal?
Thank you, Your Honor. Let's just address the elephant in the room, right? Who's going to end up with this $9 million, right? Let's talk about that. And the answer to that is, we got to look at what the folks down on Jones Street had to say about this sort of situation. Our legislature, which is the policymaking body of this state, said that when you commit an unfair trade practice, you shall pay treble damages. And there is no question that that means that the person who is the victim of those unfair trade practices is going to come out ahead. That's what the legislature intended. They otherwise wouldn't have put treble damages in there if they hadn't intended for somebody to come out ahead and for somebody to come out way behind. That was what the legislature designed when they passed this statute. And I would submit to you that it's the reason that every single time, and I laid out a long line of cases from Seafair versus Traynor through the Nash County case and the Garlock versus Henson and a number of cases in between, that every single time there has been a question before this court or the Supreme Court about whether damages get, under the unfair trade practice statute, get credited and then trebled, or trebled and then credited every single time. The court has said you treble and then you credit. Every time. Discovery is asking this court to adopt a brand new rule that has never carried the day in any appellate decision in the jurisprudence of this state. And I will also suggest to you that there is no jurisprudence in this state that so much as suggests that unfair trade practice damages can be erased ex post by anything that you do. You pay the whole thing, you pay part of the thing, you pay more than the whole thing like was done in Nash hospitals, and it doesn't eliminate the claim, which is what we've heard here today. I do want to briefly touch on a point Judge Tyson raised, which is, can you challenge it both places? Well, there's a line of cases that unfortunately I'm happy to submit a memorandum of additional authority on that says while you can challenge subject matter jurisdiction at any time, you can only challenge it one time, and you you litigate that fully there. And I think there's an opinion, Judge Tyson, that you wrote on that point. My memory may be failing me on that point, but the fact of the matter is, any challenge here today, any challenge in the Nash County action is a collateral attack on receivership, which is absolutely forbidden. Absolutely forbidden. The only place that could have been raised was in the Nash County case, or excuse me, in the Wilson County case, where they raised it. They filed the right procedure, but they lost, and they didn't bring it up to this court. They didn't properly notice an appeal and bring it before this court. I did hear a few things that I want to comment on. The statement was made that there was damages in Nash because there was a delay in payment. That is, to suggest that there were damages in Nash where the hospital had not, had not been, there was no legal entitlement, no judicial entitlement to money in Nash hospitals, to suggest that that constitutes damages, yet having a judgment against you and for 3 years and having been executed on and having valuable claims taken away from you by a receiver means you have not been damaged, frankly strains credulity and is too clever by at least half. A suggestion was made that Tomlin could have brought this claim against Discovery. That is simply not the case. Smith versus Nationwide, I don't have the site in front of me, but it's a Supreme Court case, and it says that third parties cannot bring bad faith claims. Third-party claimants cannot bring bad faith claims against somebody else's insurance company. So that's just simply not the law. And so at the end of the day, again, somebody's going to come out ahead on this. And I don't think we should shy away from talking about that. But that's what the folks on Jones Street intended to happen when an insurance company breaches its duty to defend. As you'll see in the record, the reason the duty to defend got breached is they decided to put a high school graduate in charge of making the decisions about the duty to defend who did not know what the controlling legal test was, did not know what the buzz-off case was, did not know the comparison test. And I suggest to you that when an insurance company breaches its duties that badly, that is exactly what the Unfair Trade Practices Statute was intended to cover. It is why we have treble damages, and it is why every single time the court has been faced with this notion of do we credit first and then treble, or treble first and then credit, the court has said you treble first and then credit, which is exactly what the court should do here. And so to answer your question that you last posed to Mr. Bennett, Judge Tyson, the court should reverse the decision on the damages, remand for entry of judgment in the amount of treble the underlying judgment, and for reconsideration of the attorney's fees in light of the result obtained. Thank you.
Thank you. The case is submitted. I'd like to appreciate both counsels for the good arguments, and if there's nothing further to come before the court, Mr. Saunders, will you adjourn court?
Fun as always.
Fun as always, that's right. Well, you know, some people might think you and I have a perverse notion of what fun is, Josh.
Yeah, that's definitely true. Definitely true.
Some might say.